So I'm going to be bringing some of the highlights from our research and work now together. And the speakers really over the last 2 days have really drawn out some of the key themes and topics that feature in the report. So each of the speakers' areas is something that we address in the report as a sort of top level, and they've gone into it obviously as experts in their field with specific topics. But we set out for this report, and its scope was really to map a child's digital footprint across the landscape of state education in England. So that meant from what we thought we were looking at really from age 5 to 19, when a child begins compulsory education, or at least must be in some form of education, whether that include home education or other settings. And actually, as our research developed, we realized that obviously starts much earlier, looking at the early years from even the rising twos. So children can be nearly 2 and start state-funded education on a voluntary basis. So we explored the early years settings as well. And then as we looked at some of the censuses and other state data collections, we realized actually this data collection at national level begins even younger, because when you get into very sensitive areas like child protection, the Department for Education, you must remember, is also responsible for children's social care. And the Children in Need census starts from birth or even pre-birth for children who are deemed at risk because of their child parent, the child mother. So the Children in Need census, which is being expanded next year, for example, collecting data even on children before birth. And so our scope of the research expanded a little bit as we went along, but we tried to stay within the confines of mainstream education for the most part, because once you get into alternative provision, specialist educational needs, special schools, looking at youth offending provision, you get into even more complexity and in-depth that we just didn't have the capacity to address. But we focused from age 2 to 19 on the statutory data collections in state education in England. Some of these then broadened into Wales as well, but we focused because education is devolved on England primarily. And we mapped the censuses, the 7 different censuses that can happen to a child as a result of being in state education, whether that's the school census, or whether if they leave mainstream education, they go into alternative provision and fall into the alternative provision census. And then those that are specialist for children with additional risk factors, as we talked about earlier, the Children in Need census or the Looked After Children census. And we discovered 7 different censuses, all sending data about children termly or annually to the Department for Education. We then also addressed where that data goes and how it's used once it gets to the department. So most of those data sets feed into the National Pupil Database, and we built on work that others in civil society already done before we began in 2016, 2017, looking at this in more detail. And through very little information actually in the public domain at the start of our research, we obtained a lot through Freedom of Information requests from the department over the last 4 years. Most of that data should be in the public domain. And this is what we are seeking to change, is to actually put all of our research into the public domain, including all of our Freedom of Information requests, any parliamentary questions that we have seen as relevant in the topic areas, as well as our own research. And so we built this report into 5 parts. The first is effectively an executive summary, our key findings and recommendations. This alone is around 80 pages of A4 and addresses 10 different key topics. And then the background to that work we'll put into an online repository. And our aim is that anyone can access that data and research and build on it. And we hope then to keep this as a living repository that we can keep updated with ongoing changes in technology, changes in the school censuses that happen in the national data collection, in assessment and testing, and also updated with case studies. So we've included in part 2 of the report a number of case studies from the commercial sector of what types of EdTech are most common in the majority of England's schools. And we reviewed the privacy policies of 100 different most commonly used EdTech providers and platforms. And again, the links to all of these will be in the research. We're very grateful to volunteers that have helped us, to other civil society organisations, and of course to our funders, Joseph Rowntree Reform Trust, for funding this research work, and also to all of the school staff, teachers, parents, young people who've contributed, academics, particularly we must draw out Ben Williamson in Edinburgh, and who's really contributed a great deal of findings, Alice Bradbury as well on baseline and early years data collections, and thank everybody that's contributed, both named and not named in the report. So effectively, our key findings we got to is that by a child's fifth birthday, families have lost control over their child's digital footprint, their identity and history of the data that's collected about them, simply by attending state education. And families and children really need to have practical ways and means to realise their rights. And this route to realising rights doesn't exist today in the education sector. And we want to change that. We want to build a rights respecting environment in the education sector in England. And we're hoping that some of the businesses and commercial operators that also contributed to our research and learning in the report will help do that and see the need for this transparent, fairer, more just and rights respecting environment, in order that, particularly in the direction of travel for EdTech, that we build a trustworthy environment. And if the EdTech sector is going to flourish, that's what we need. So we built really 10 areas of recommendations. I'm going to draw out just some of them. The first area of recommendations is around legislation and statutory duties. And we would like to see an Education and Digital Rights Act to govern children's rights across the education sector. And this goes far beyond the data protection questions, because people will say, look, we've got data protection law, what does that matter? It's much more about building the rights infrastructure to be able to not only manage information, but to understand where and what rights exist beyond data rights. Things like participation in research trials. What does it mean if a school adopts a product and you don't want to use it? Where have you got routes for redress when things go wrong? What happens when mistakes about you get recorded and you don't have routes to get them rectified? These are not questions of just data, but actually, where do I go to? Who is my champion? And we don't have someone in the sector right now that can be that ombudsman for children. And we would like to see a regulating sort of body that has oversight of the whole of the education sector, effectively a digital guardian for children, similar to the role of the National Data Guardian in health, but it really goes beyond data and looks at the bigger picture of ethics and rights that children have across participation, accessibility, exclusion, and really championing that broad picture of rights and respecting environment. It needs to consider things like standards and procurement. What does it mean when the technology should be accessible and inclusive? What design standards are we needing? We need to address things like data justice and algorithmic discrimination and accountability, as we've seen so chronically needed, highlighted by the exams fiasco this summer, and ensure that introductions of products and services to the classroom and research projects have consistent pedagogical value, efficacy. They're tested for safety, for quality and health standards as well, because increasingly technologies, as we've seen from today's presentations, are biometric or looking at very invasive data collections, but that have actual physical effects on children, as like Erica Southgate's research in Australia found in immersive virtual reality situations, this kind of VR sickness that can trigger some of these questions around safety and efficacy of data collections for children. So we talked about earlier as well, what would fall into that Digital Rights Act would also look at the core national infrastructure, responsibilities and accountabilities and ownership, and that it must be put on the National Risk Register. Dependence on products like Google for Education, MS Office 65, and even the cashless payment systems. Schools would find it very difficult overnight if these systems fell over. And we need some sort of infrastructure accountability that goes beyond private actors. And we would like to see duties on reporting, transparencies and obligations, and understanding how these key functions really play a vital part of the public sector delivery of education today. So this legislation would come accompanied with codes of practice and enforcement to prioritize the full range of human rights of the child in education. And this is backed by, not just an ask, but really the requirements that we're falling short in today, that we're in accordance with the Council of Europe's recommendation on to member states on guidelines to respect, protect and fulfill the rights of the child in the digital environment. Stakeholders, across the education sector must also respect the UN Convention on the Rights of the Child, general comment on state obligations on the impacts of the business sector on children. Those guidelines exist, we just don't really take them into account today, and we should and we must, and they must become part of our whole approach to procurement. This national oversight body would need to be on a statutory footing to oversee data in education, and also, as we said, accessibility standards for education for products need to be defined and part of procurement to ensure fair access for everyone and to reduce digital exclusion, not only in terms of do we get broadband, do we have devices, but once I have them, can I use them? And with a huge range of different abilities and needs in children and their developmental needs, particularly as children, this is very different from adults. They may not be able to voice themselves everything that they need, but we need to make products by default and design accessible to all. So the national strategy right now really is about products and particular products, individual products. This is how a special product can help you in the classroom. We think it should take a different approach. It's not to say that this sort of EdTech demonstration model is per se wrong, but it's a different value set or a different approach that could enable the same aims through a different, and I think a better route. Because if we started with people, with teacher training, with introducing skills, including data protection and privacy training into basic teacher training, we would be able to deliver, I think, more confidence in staff delivering using tools and give them the clarity and consistency they need to make sure that every child is getting a fair standard, a just standard of education across the country, and not, if you like, the sort of postcode lottery that they've got at the moment where two schools in the same town could be running a whole different set of tools. And there's not to say that that's not appropriate for different schools to run different tools, but that we should make sure that at least it's done in some sort of understanding of fairness, that it's not because one school has managed its budget differently and that different children in the same place are getting a different level of education, which is dramatically unfair simply because of where they live. So we'd like to see a white paper to start this ball rolling, address the sector-wide changes needed, focus first on people first and pedagogy as perspectives rather than products per se, and to look at the access and equality issues, this sort of lack of social understanding that exists in products can't be brought in just by delivering products better and faster. We need to put this sort of the infrastructure that underpins the social needs of children and families in as a sort of social contract behind how education is delivered using technology. And that's why an Education and Digital Rights Act would be able to pick up some of these issues and concerns, as well as horizon scanning. We're looking at the securing the necessary infrastructure we need to deliver education, but with the governance models that are needed for a safe, just, transparent digital environment in education. So we think there's basically topics that need addressing: the role of families and children's agency, including representation and remedy, the role of school staff, and where does the boundary lie between a school's responsibilities and the responsibilities at home? So as we saw in this morning's panel discussion with Ailey Calander, Leo Ratledge, Georg L, led by Anne-Marie Christian, what is the ethical boundary in a school that has adopted a internet or digital monitoring tool that monitors 24/7 whenever a child logs into the school network? Is it right? Is it ethical that the use of their computer or phone, even a personal device, if the software or systems deliver on bring your own device, as many do, that their internet usage can be monitored even when they're at home outside of school hours or outside of the school premises? And where does that boundary of responsibility lie? There's a difference between monitoring for the security of the infrastructure of the school system, monitoring firewalls and safety and access to the system, versus monitoring the children as individuals and monitoring for risks and putting flags on them as potential gang members or at risk of suicide. And where does that boundary lie between school and home? There's gaps in legislation and in the statutory guidance there. So an area moving on, which needs addressing in teacher training, for example, continuous professional development, giving teachers the skills and the confidence to deliver using some of these tools that they're being asked to. And going beyond that, looking at things like discrimination in data. How do teachers understand the biases and discrimination that's possible to read into data if they haven't been given the basic tools of teacher training? And Dean Bernard raised some of those issues yesterday when looking at that session on exclusions. And it's really important. Teachers have been put in a position of collecting huge amounts of data and creating huge amounts of data through the assessment and accountability models we've got today. But when they get those reports back and the benchmarking and the data analytics, have they got the skill sets to be able to identify where the data are wrong, or where the algorithm has suggested risk scores and profiling for children in progress measures that are inaccurate or that are biased? And has there been assessment of those models? We don't think there has, and there should be. We need to reduce the investigative burden for schools. So when on new technology introductions, the complexity of some of these tools that we've seen over the last couple of days introduced, so things like the latest biometric technology, facial recognition, emerging technologies using adaptive learning and AI, going beyond that into virtual reality and immersive technologies, or even the things that we've not talked about so much, but are emerging and are being adopted and promoted at tech shows in the UK like BET, brain scanning technologies, the type of tech that even some companies in the UK might develop, but families in China, for example, pushed back on. They didn't want this brain scanning technology that was applied against every child in their classroom, and they rejected it. So when teachers are being put in the position of procuring tools, if they haven't got the skill set from basic teacher training, they can't be expected fairly to really understand what it is, the implications of these technologies and their data implications. And so we think there needs to be actually a new infrastructure for managing due diligence in schools. And it would go back to some of the regional or potentially a national infrastructure model of support for schools, so that when they have a need for introducing some sort of technology and tool, they have a consistent framework for understanding whether it's approved, whether it's safe, whether it's storing data only in the UK or sending it abroad on a very technical level, or whether it's ethical. Where is that sort of value set? Should we adopt some of these technologies? Doesn't have an infrastructure for asking those questions today. We think there needs to be changes at looking at the permanent record. So the permanent single record that sits at the National Department for Education at the moment. But we'll draw out basically a chart in the report, and it looks at all of the national pupil data collections and really maps out all of the censuses and all of the potential points of data to be collected. But you see at scale then what the permanent single record for a single child might look like from age 2 to 25. So some of these collections going beyond 19 when children are in care, for example. And then we've got recommendations on assessment, attainment, accountability, and profiling. We think lessons need to obviously be understood and acted on quickly from the summer 2020 exam awarding process. The statistical assessments being done by the UK Statistics Authority is very important, and it needs to not only address what happened this year, but look at the modelling behind the exam's comparable outcomes systems using Key Stage 2 data and GCSE prediction reference grades, and looking at how the explainability of that comparable outcomes model is communicated to children. For example, we had suggested to Ofqual earlier this year that they produce a template report that would be able to be downloaded by schools, integrating the information that had been provided by, whether it be an actual exam sat, or whether in this year's case it was the teacher assessed grades or the centre assessed grades and the rankings that were submitted, and then the data behind the scenes that the exam boards have to use in order to deliver comparable outcomes, looking at historical data. And we wanted to be able, for a school to be able to download a report that integrates those different data sources and shows to a child or a young person, here is your exam result and here is how it was calculated. Now, if it's not possible to do that, we should ask why. Now, if a system is so complicated that it can't be explained to a person, it fails in its fundamental obligation to be explainable, understandable, and fair. And we need to address that not only from a data protection question, which is why Foxglove Legal brought about the challenge this year, but also just from a practical perspective of whether that's a sensible system to be have for children and young people if they can't even understand their own exam awards process. Because even every year, even when children do sit exams, it's not just about the score that you get on the day. It's all about comparable outcomes and ranking people across the system. And really this year, sort of that cap on aspiration was obvious to everybody. I think for the first time that we realized more broadly, it's not just about how you achieve on the day. We're recommending, when it comes to assessment and attainment, the accountability system should really be putting a stop on at the moment, and the Department of Education should put a moratorium on the school accountability system and league tables at least until 2025. While the assessment is carried out on these questions of fitness for purpose of these data, but also recognising where pupil data is going to continue to be affected by COVID-19, making comparable outcomes across schools and competitive measures meaningless, and they may well be misleading. And if they're not useful, if they're not accurate, you shouldn't have them at all. That would mean a pause on the early years foundation stage, baseline, multiplications times table check, and as a whole, just put a pause on those three areas. From it doesn't stop local areas making their own assessment data. In fact, it gives them the time and the capacity to focus on the data assessment they are making at local level and make it meaningful then for their children and for their teaching, and takes off the pressure of having to submit these national scores for the Department of Education, for the accountability system. And instead, we could perhaps focus the targeted data needs that the Department of Education has, perhaps looking at the phonics and sampling Key Stage 2 SATs. So sending sampling data of those two areas up to the department instead of every child's data at every individual child's named level. Because the pause on standardized testing that happened this summer shows that it's possible. So Key Stage 2 SAT, for example, was scrapped this summer. And, you know, Leckie and Goldstein's Harvey Goldstein's research in 2017 concluded that the evolution of school league tables in England, that all of these progress measures and school league tables more generally should be viewed with far more skepticism and interpreted far more cautiously than what they might often have been to date. And it really does seem like the right time to take into account, you know, his recommendation and his deep expertise in that area, that these data are just not fit for purpose. We also recommend that we need to separate out teacher assessment from accountability measures and performance-related pay. Now, this is something that's adopted not consistently across the sector. Only some places adopt performance-related pay, but it doesn't promote accurate and reliable data. And by separating that out, we would remove the unintended consequences of these sort of distortion effects and the incentives in the system to produce the data as the goal rather than assessing children to support their education primarily. For example, we also, in our research and discussion with a great number of people, recommend that the reception baseline assessment should be either stopped completely or certainly have an in-depth review. It's got a number of significant problems with its approach regarding data protection and in its design. It's problematic from an equality and disability rights perspective, given that the same approach is not inclusive for all. And when we reviewed the data protection impact assessment for the baseline test, it omitted many of the risks, including its adaptive test design, which was just not mentioned. It omitted the reasons, for example, that not taking the test were included, which can include recently arrived with English as an additional language. And it didn't mention that the data, once they're collected, go into the National Pupil Database, and from there will be accessed by all the third parties that the National Pupil Database is accessed by today. And we have analysed that access, and until June this year, there have been at least 1,600 individual requests for data that were fulfilled. About 40% until 2016 had been to the commercial sector. That balance shifted a little bit after we started asking some questions and asked for more audits, which had not happened at all prior to that. And identifiable pupil data is going out at scale. The department can't tell you if your child's data was included in a data release. They don't know which children are in which data release, even though it's identifiable pupil level data. That's a basic failing of data protection compliance. We also found, for example, that the releases for children's non-educational purposes have been growing. So since 2015, and as we discovered it in 2016, the Home Office has been getting access monthly to children's educational records from the Department for Education when the Home Office submits a list of names from which they want to match individuals in the National Pupil Database. The Home Office had submitted nearly 6,000 requests, 5,998 requests between July 2015 and July 2020 to the DFE, of which 1,545 were fulfilled. So that means the DFE has handed over children's data from the National Pupil Database, collected solely for the purposes of their education, to the Home Office for the purposes of immigration enforcement and for the hostile environment. Now, remembering that that was not made public by the department, it was only exposed through our own research work and the support and cooperation from other civil society organisations, including Against Borders for Children and Liberty in 2016, when the government started to collect nationality and country of birth. And we raised the flags at that time, raised the concerns, because exactly at the same time we had discovered for the first time that for over a year already, Home Office had been getting access for those purposes. Now, we managed to put a stop on the collection of nationality and country of birth 2 years later, because in 2018 that collection was stopped. But now there's still questions of why is the department holding that data? If it's not being used for the purposes it was collected, it should no longer be retained. And we would continue our cry that that data should simply be destroyed, nationality and country of birth that was collected for the purposes of the Home Office Memorandum of Understanding, which is public and on our website again. We asked recently the Home Office to explain what it then does with those children's data. And there is no accountability. Once the department has handed over those names and details, the Home Office was unable to provide any other information of what the outcomes of that data use is. We asked quite simply what, from those 1,545 children's data handed over, what had happened next, what were the interventions? Was there some sort of immigration enforcement, visa work, removals, what happened. And the Home Office has replied that it would cost too much for them to find out. We think that's appalling. The department had also enabled in 2018 185 children's identities to be handed over to the Department for Work and Pensions for the purposes of fraud investigation. And in last November 2019, the department allowed police to access over 2,000 children's names, all at the same school, for a criminal investigation. Now, why the police could not simply have obtained that data from the school is very unclear, because there is no reason why the names and details of the children held by the school would not have a lawful basis for the police to access, compared with going to the National Pupil Database for it. These questions of use of National Pupil Database for Home Office, for fraud investigation and policing raise really serious questions about repurposing and the trustworthiness of data sent to the Department of Education, and whether that oversight process is fit for purpose is, I think, at high time that changes happen, and those excessive use of national pupil records ends. Otherwise, it will actually jeopardize, I think, the entire national data strategy that the UK has. It will jeopardize public trust in public interest research and the use of data, for example, by the ADR and linked data sets at secure settings. And people will simply stop submitting accurate data, and or, as we already know from the questions and cases that we had when they started collecting data from the hostile environment in 2016, children will be taken out of school. And that's where the most fundamental harm is done, where children can no longer enjoy their right to education because of fears around how information about them might be used. So this falls into our third area of recommendations around admin data collections and national data sets. And to highlight just the top line of that, Nesta proposed in 2019 in its report, Education AI Rebooted, that the government should publicly declare an ambition to create a system of responsible education data sharing by 2030. It somewhat suggests that they believe, as we do, that there isn't one today. And we agree with both positions, but 2030 is too far away, and government really needs to get that governance framework in place sooner and start building it with urgency. We look at, in our fourth area of recommendations, principles and practice using technology today, and go on to look at EdTech evidence and efficacy. The digital environment must serve children well. It has to be safe, inclusive, and equitable, promoting social justice and human dignity. I think the EdTech strategy across England, if it's going to work, needs investment in people, pedagogy, and local infrastructure. And we really need to look at it from the ground up in a different way. There's all sorts of technology that parents are given to reporting on their children to the nth degree of benchmarking, performance, behavior, not only that they ate a meal today, but exactly what they bought, item by item. And there's degrees of data that parents simply may not need or may not want. And yet we're not looking at it from families' perspective or from what children need in their actual day-to-day interactions with tools. And if we need to address all of those sort of hopes for the EdTech sector, both from its beneficial applications in education and learning, and also fulfill that sort of second purpose of the hopes of the EdTech sector as an export market, we really need to look at that element first of children first, championing safety and pedagogy, and cutting out the harms that some of these techs can do as well. And we, in our second part of the report, that will be online only, look at case studies, for example, in a company that has claimed for years that its unique selling point was AI, but in actual fact doesn't contain any AI, and has changed all its website marketing materials this year. There's questions around safety in various tools and technologies like immersive VR, and the brain scanning techs that we mentioned earlier. Some of these technologies probably just shouldn't be in schools at all. And these questions need to come into this, both codes of practice and in legislation, to guard against not only the risks and harms to children, but also Department for Education's reputational risk. And if the EdTech sector is going to be supported and successful, both in its homegrown support of children's learning and as an export market, we need to put product integrity and safety standards higher on the agenda. And that's not happening at the moment in national recommendations at all. Any of the roadshows we've been to, any of the tech sector market shows, the bets, the academies show, and the big sort of promotional tours that BISA and others do, nobody's looking at due diligence, looking at data protection legislation or the legal aspects or the ethical aspects of some of these technologies and their integrity, their financial backgrounds, who owns them, how are they being run. Even looking at the early years apps that the Department for Education promoted this year in spring, some of them we would question whether and how the due diligence was done before their rollout. We then go on to look at, really focusing on children's rights, looking at the world that talks about ever greater personalization, and in fact, how children are being treated less and less as an individual, but rather as a single data item in a cohort and by comparison. And devolved nations have actually made greater efforts than England to establish a national child rights framework across the public services delivery. So Wales has a Rights of Children and Young Persons measure in 2011, and in Scotland, the Children and Young Peoples Act 2014, and last year, in fact this year, adopting even the child rights impact assessment as integral to public services. We need that in England as well to strengthen a unified and outward approach to children's rights. And it would bring that sort of consistency across the union for businesses in the public sector with a more sustainable, standardized set of expectations that I think would support business as well. And industry could then work with a more uniform set of standards that would support everyone. Obviously, these have implications for local data processing. And one of the highlights we'll draw out there is, for example, for management information systems. So there are about 15 different providers of core information management systems across the education sector today. 80% of that market is owned by Capita, as we understand it, currently up for sale. But at the moment, some of those systems have told us that it would be too expensive for them to be able to manage the granular level of data protection permissions that are needed on data sets to both meet local school needs and the permissions that they should have on the same piece of data for national census collections. So for example, ethnicity, it should be an optional item for the national school census, but if the system doesn't permit it to show more than one type of permission, then it's either in the system or it's not. It's either available for local use or it's been refused. And you can't have the same piece of data with two permissions, so that the school could hold, for example, a granular level of ethnicity, but the parents have expressed they don't want that to go to the National Department for Education, and that is their right. It's currently one of the only four, out of about 400 different pieces of data that can be opted out of and the national censuses. To get closer towards the end of the report, we also look at the bridging year, effectively, between standard or compulsory education up to 18, and that bridging year into higher education. So we address some of the questions that we've looked at in some of our work over the last year, for example, inequality monitoring, and make recommendations that any equality monitoring data should be collected and anonymized at source, and only statistics passed around the system to the higher education funding bodies and to the National Department of Education. Whereas at the moment, if young people volunteer their sexual orientation, their disabilities, their religion, then that data is collected at named level and then is passed to the Department for Education on a named basis, which means that 3.2 million young people's religion is currently sitting alongside their name in the National Pupil Database. We think that's dangerous, and it's not only reckless given the current approach to Home Office data sharing and the potential questions that could be there, but also looking to future governments and being realistic about safeguarding not only for today, but the unknowns of other governments and future positions that might use that data differently. We only have to look to history to see how realistic and dangerous that can be. A recommendation for that first year of higher education that also goes beyond is a student loans company needs to stop their surveillance of students' social media, particularly in investigations for fraud, particularly where they're looking at estranged students. And if they don't end it completely, investigations for fraud at least must not communicate to the institution until suspicions are proven, rather than today's case where students can have their funding stopped and then months later find that their innocence is proven, but by then it's too late. They don't have this financial support to carry on at university, and lives are permanently harmed and changed as a result of that, and it's completely avoidable. We also make recommendations there should be absolutely no transfers of data from the Prevent programme from further education or colleges or schools into higher education, as the Med Act discovered this year, and we did some work on colleges in Manchester were setting up a memorandum of understanding agreement process to transfer data on the Prevent programme from further education colleges to higher education, and that should just be unacceptable. There's no reason, if it's a consensual programme, as Prevent claims to be, but there should be absolutely no reason why that sort of arrangement should be done in secret, and anything should be consent-based, if at all. We also look in more detail at plagiarism, proctoring, and data analytics, but we won't go into that now. We've got recommendations for research, looking at where the public benefit must be a prerequisite for research ethics approval for trials in schools, and that includes products as well as academic research, and must always be about the best interests of the child. We would like to see an independent oversight board established for every product and research trial in educational settings, and published which sort of trials are going on and their approvals process in a similar model to the confidentiality advisory group in health. There's no current national register of every trial going on in England, and it is extensive. The amount of research trials, both academic and product, and through think tanks is phenomenal. And if every school is a research school, as one of the mottos is in one of these programs, then that means every child's a potential research subject. And at the moment, there's no independent oversight of how many times a child, for example, in their entire education might be subject to a product test or a trial to influence their behavior or to influence their achievements or attainment. It has significant ethical questions for children when these trials are happening in regular education and parents can't remove their child because it would mean taking them out of their everyday teaching. There needs to be this board would also have a single national view that's public of every trial going on, and they would be searchable in an open register so that parents and any other interested party could see transparently how many trials, about what their intended outcomes were to be, and how often certain schools are taking part in what trials. The public benefit has to be prerequisite for a research approval, and those ethics approvals should also be in the public domain. Again, there's no reason why not. And if we're asking parents to trust schools to trial products and academic research on their children, I think it should be an absolute outrage to find, as I did, that we're not able to access data protection impact assessment or ethics approval for trials, or to take our children out of them and their interventions. And our last area for recommendations in the report is around enforcement. There hasn't been any in the education sector. In effect, there were some reviews, and again, we've published those on our website already, of done by the ICO, but there's very little in the terms of actual enforcement that makes a significant difference. And of course, it's very difficult when enforcement was sort of trumped by sort of GDPR, newly invented new GDPR training bodies in 2018, that this was all about fines. And in fact, it should be much more about stopping bad practice and harmful practice, but also encouraging good practice. And so we think there needs to be a much stronger approach of enforcement, but not by single schools, but actually looking at EdTech companies as the focus of enforcement, because that will then have beneficial effects where change is brought about sector-wide and affect many thousands of children rather than an individual school approach, and improving the standard of sort of sector-wide information and training in terms of children's rights and the law has generally been of rather low quality, often with misleading information given to schools. We've certainly talked to both product providers and schools who have a very poor interpretation of, example, controller and processor roles. And this is key when we're looking at the legislation and the law applying to accountability. If a processor in a school, a third party, is determining who gets the data after the app has received it, that doesn't make them a processor. That means they are a data controller. And at the moment, we find the vast majority of apps and platforms that seem to think it's okay for them to just take that decision on their own, to then depersonalize data, take some bits off and make it less identifiable and pass it around the sector for research purposes, for example. That's not the case. If they only have the authority to do anything as a processor, they haven't got the authority and therefore not the lawful basis to be able to pass that data on just because they determine they want to or they should for research projects. And that even has questions for the latest government funding of research, for example, and to lockdown effects. So there's lots of questions. We've got these 10 areas of priority. I'm going to wrap up there, otherwise we could go into all of this in a lot more detail. But really, we're going to, I wish at this point I could say to you, here is the finished report. All I can say is it looks something like this. We're just about there, but we've actually to still put some of the final touches on it. And we have been very diligent about getting rights to reply back from companies that we put in case studies. And we're still getting some of those finer details into the text. So we hope that it will be ready, if not Friday this week, then certainly early next week. And we'll be putting all of this work, as we said, into the public domain, free and open access, as a report, part 1, as summary of what we've just talked about and the recommendations, and then all of the other work and research. And we hope you'll help to contribute to that. Genuinely want to be able to build on this, to build up that sort of baseline of knowledge of what information is collected about a child across their journey throughout education that wasn't available to me as a mum of 3 children just 4 years ago. I had no idea which companies, which third parties, which national data collections my children were involved in. I had no idea where their data went. And as the Children's Commissioner said in 2017, every child should know, who knows what about me. It has profound impacts, not only for their education, but for the rest of their lives. As we saw in some of the talks yesterday, this data being used across local authorities for prediction and child risk scoring, going into national databases, now being used for all sorts of purposes, many of which are punitive. So we really need to put children's rights front and center of all their data processing and education. And we think that can only happen through an Education and Digital Rights Act, legislation with standards and codes of practice in place that today we simply don't have. So I'm going to wrap up there. Listen, thank you very much for all of your kind comments and contributions. I hope you'll take the report once we do have it. Please look out for it on our website. We'll post it on Twitter as well, and that we can carry forward these conversations. This should not be a 2-day event. This should be the start of a new national conversation about what we need to support a digital rights respecting environment in education in England. Thanks very much.